Hello, my name is Herbert Wiggins. I'm the owner of Herbert Wiggins, a professional law corporation, law firm in Lakewood and Long Beach, California. I focus on bankruptcy and debt matters as well as commercial matters. Today I want to speak with you about the 4 T's. The 4 T's are truth, title, transfer, and trustee. When it comes to bankruptcy proceedings, you're going to be under oath. Whether you're writing your papers, putting in the list of assets and debts, whether you are with the U.S. trustee in something called the meeting of creditors, or in the court, at all times you are under oath, the same oath you would be under if you were in Perry Mason, taking the oath to testify before the court. You're asked to swear as a witness if you go on the stand in the bankruptcy court. You swear as a witness when you go before the U.S. trustee in the creditors meeting. So what that means is you have to always be credible. Don't shade information. Don't appear to withhold information, because it'll be very obvious to the trustee that you're not being forthright. It'll be very obvious to the judge that you're not being truthful. And if the judge or trustee feels that you are withholding information, it can become a very unpleasant experience. And that's not what you want. When you go into the U.S. trustees meeting, the 341 meeting, you will see a banner on the wall, especially in downtown Los Angeles, saying that you are under oath. And all the proceedings are being recorded, and if it appears that you're untruthful, you'll be referred to the FBI. Okay, so you don't want that. You want to always appear truthful. That especially is important when it comes to what you own. Anything that you have title in, anything that you own, whether it's in California, the United States, Western Europe, former Soviet Union, doesn't matter. Anything that you have title in, anything you have an ownership interest in, is your property, and you have to disclose it. Whether it's an interest in a trust, a car, a villa in Panama, a ranch in Mexico, you have to disclose it. Okay, so don't take the position that, well, it wasn't in the U.S., so I didn't have to talk about it. Or, that was given to me by my mother, and it was in our family for 5 generations, and it happens to be in Canada. It doesn't matter. If it's your property, you must disclose it. That way, the court knows you're being truthful, you're not hiding anything, and it's going to increase the confidence of the trustee and the bankruptcy judge in your word. If there's a question of whether you're believable or not, you always want the court to side with you as being believable. That comes in especially true when you come to transferring property. There's something called the preference period. The preference period is typically the 90 days before your bankruptcy filing, but it can go back as far as 2 years if the U.S. trustee believes there's something that appears odd about property that you're transferring. An example would be that 2-year-old Mercedes-Benz that you suddenly turned over to your son a week before the bankruptcy, or that house in Saratoga, California, worth $1.5 million, which you turned over to your brother-in-law a month before the bankruptcy filing. Those types of things will look very suspicious. You could become liable for what's called a fraudulent transfer, and the transfer could be undone by the trustee as being accomplished during the preference period, because it looks like it's property given to one creditor to defraud other creditors, or given to a person to defraud all the creditors. And you don't want that, because anytime the word fraud appears, it means your credibility is in question. And again, you don't want your credibility to be in question. Now, the person you're going to be dealing with most in your bankruptcy proceedings will likely be the U.S. trustee. The U.S. trustee is an experienced CPA or attorney who's probably handled many bankruptcy cases and is in charge of your property during the pendency or during the existence of your bankruptcy case. So when he or she asks you at the 341 meeting, which takes place about a month after you file your petition, he's going to ask you if you declared all of your property and all of your debts. And you're going to answer truthfully, yes. And you're going to talk about everything in your papers that you have in LA County or any other county or any other state or any other country. All right, so he or she's not going to have to worry that you're not telling the truth, because if it appears that way, then you're in deep trouble. So always be truthful with the trustee. The trustee can be very pleasant to deal with if you're truthful and very unpleasant to deal with if you're not. Always remember not to transfer your title to property during the preference period or in any way that looks like it might cause a question for the U.S. trustee. Truth is always going to be the best policy in bankruptcy court, as it is in other places, and if you are truthful, you will not get any unpleasant surprises, such as the revocation of your bankruptcy 5 years later because a trustee has disclosed or discovered through a tax return that you withheld information several years before. So be truthful, honest with your attorney, honest with the court, and you'll likely have a very smooth process to receiving a clean slate in bankruptcy. Thank you for your attention. I look forward to any questions that you may have. Thank you.